This is KTN News.
Civil society groups are this morning have named former Devolution Cabinet Secretary Anne Waiguru, Governor Alfred Mutua and Evans Kidero, Hassan Joho, Mike Sonko and 15 others among aspirants who are unfit for public office. The activists under the Integrity Alliance want the IEBC not to clear them for the August election over integrity issues. According to the activists, those named fall short of ethical standards set by Chapter 6 of the Kenyan Constitution. So others also named were Alfred Keter, Alfred Mutua, Asman Kamama, and Elizabeth Ongoro. We'll get you the full list in a bit. You're watching News Center. Thank you for staying with us. Allow me to introduce two gentlemen in my studio who will help us look at what are the consequences, the implications of this particular list. We have Joshua Kiptor and Muregi Kamande, both advocates. Thank you, gentlemen, for joining us on News Center this morning.
Thank you so much. Thank you.
Joshua, let me begin with you. So we have a list of aspirants who civil societies are saying should not hold office. What are your thoughts?
My thoughts are that I hope we are aware there's a case in the Supreme Court where the issue of integrity,
Kenya National Commission on Human Rights,
implementation of that Chapter 6.
Yeah.
And I think we are just at this point because of the failure of Parliament. In 2012-2013, after our enactment of the Constitution, Chapter 6 was clear that Parliament was given the mandate to come up with a legislation that will put into effect Chapter 6. But the legislation that was passed by Parliament and approved, as per now, was seen to be weak and not having the ability to be able to have that Chapter 6 being effective. So what happens? You've had a case in 2013 where the vetting wasn't effective. Anyone with any integrity issue came through.
Yeah, and everyone just
yes, everyone came in. And in fact, I remember the argument that if we haven't taken it out against our top two leaders by then in 2013 with a question on ICC, then no one else should be. So that was the argument and it stuck. Now for 4 years, none of these institutions went out of their way to try see how they can enhance their capacity. Talk about EACC, DCI, none of them really proved that they have an ability to work. So the net effect is that we've had a backlog and we are here because of the failure of these institutions. To the extent, therefore, the question remains, who is there now to come and give us that scorecard and say this one qualifies, this one doesn't qualify. So IBC is in trouble because now when you have such a petition which is anchored in law, it becomes a bit of a difficulty because IBC will say we need some prior info. We need some solid info so that this same aspirant can't go to court and seek orders blocking us from blocking him or her.
Oh, trust me, they
So
will.
what happens is the case is who is the custodian of this? So it goes back to the failure of the institution. And I will not even blame wholesomely EACC and the rest, but it will start with the legislature. Parliament was supposed to come up with a strong legislation that failed at that initial point. So what is the next impact? The institutions are kind of not as effective and powerful as it is. And then again, my analysis also is that it's too late in the game. Look here, political parties ended up clearing the same aspirants. And I remember part of the requirements was that you have to get all these clearance from these agencies. Now, that was already done. That's water under the bridge. True, we need to implement that chapter, but I'm just worried about the timing. Look here, we are already in the silly season. The emotions are already running high. The voters have already made their choices.
What did you call it? What season?
It's a silly season where emotions take the better of us.
Yeah.
What do you think you'll tell Kirinyaga voters after the 100,000 of them voted
We
for?
scrutinized your candidate and she failed the integrity test.
True, but the voter will tell you we have the same constitutional right to decide whether we want him or not. So the end product is IBC is in a very difficult position. I think they will fear taking the action of barring anyone. These are things we should have done 6-7 months before.
Not now.
We have not done it. I'm really concerned as to practicability. But the beauty is we are starting. This is something that we would have said early enough, but it is good we are starting now.
The unfortunate bit is you're saying we are starting, but then in the same breath you're also saying you highly doubt IBC will be able to do something.
I'm mixing two things. It is good to start because it is for posterity, but the reality, can really these NGOs have the ability to stop? Fine, they will do everything, they'll go to court, but I think ability to implement will be difficult. One, IBC will be scared because look at the personalities named and the vote block they control. IBC will not want to muddy the waters. And secondly, I think at the end of the day, the person who will arbitrate on this will be court. These matters will end up in court. And in that case, I'm happy because the court is not a scared institution. So they will give a favorable ruling that whatever the court gives, then I think that is what IBC will rely upon. But on the basis of it, the beauty or the reason why I'm saying it is good we are starting somewhere is that these are the things we should have dealt immediately after the 2013 elections. We didn't. We always like doing things last minute. Now we are here.
Commander, what are your thoughts? Yeah, I know.
First of all, he's pointed out about legislation. One thing you have to give it to Parliament. They did enact the Leadership and Integrity Act, and the Leadership and Integrity Act was I would say a copy pasting of Chapter 6. You see the Chapter 6 of the Constitution, the same provisions are what were lifted and was now transformed into an Act of Parliament for purposes now of bringing into effect the Chapter 6 of the Constitution. But going forward, what you see right now, those names that have been named there, we also need to interrogate the basis upon which they want those people barred from by IEBC.
Okay, hold
yes,
on.
because that would also be important.
Let me tell you. Let me see, because I think I was drafting some of them.
Yes.
Alfred Keter, breach of Chapter 6 and Leadership and Integrity Act following that Gilgil Way Bridge saga.
Yes.
Yeah.
Yes.
Alfred Mutua, procurement irregularities, something linked to purchase of Subarus in his county.
Yes.
Anne Waiguru, investigations relating to NYS.
Yes.
Asman Kamama, involved in ongoing clashes.
Yes.
Ferdinand Waititu was already declared unfit to hold a public office. Elizabeth Ongoro, violence during party. Actually, let's listen in. Let's play that for you.
(2015), and you will find this reported clearly in the Ethics and Anti-Corruption Commission report of 2015. There is Alfred Mutua, who is sitting and also is aspiring to be the governor for Machakos County on Maendeleo Chap Chap, and he faces allegations of procurement irregularities of purchasing 12 Subaru vehicles worth 147.3 million, among others. There is Anne Waiguru, who aspires to be the governor for Kirinyaga County on a Jubilee ticket. And Anne Waiguru has investigations relating to the NYS theft, in which up to 1.5 billion shillings was lost. In fact, to correct myself, at least 1.9 billion shillings have been lost. And this was happening under her watch as the CS for devolution. And the audit that has been carried out and the investigations that have been carried out, of course, established that this money was lost. Just this month, the National Assembly Public Accounts Committee did pronounce Anne Waiguru unfit to hold public office. And the special audit report on the National Youth Service as well documents these issues. There is the case of Asman Kamama, who aspires to be a member of parliament for Tiati constituency on a Jubilee ticket. And the allegations are that he is involved in ongoing clashes and suspected of involvement in assassination of opponents. And there is a case.
Okay. So there we go.
Yes. Now, it's good to have the clip has been played. If you note whatever, what do you call for the gentleman from Transparency International saying, there is 3 consistent terms that they've used, and I was very keen noting them. One is the term allegations, 2, investigations, and 3, And the same one is repeated when it comes to Asman Kamama, allegations. So what we need to interrogate right now is one.
Yes.
We have the Constitution of Kenya 2010. Yes? Mm-hmm. That is what we call the Grundnorm. That is the basis from which we need to interrogate these issues. It is the basis on which Chapter 6 is founded. And we have to ask ourselves, is integrity a standalone consideration? Mm-hmm. Yes, when it comes to leadership. Does the law, for example, the Constitution, provide for means with which we can resolve this issue? I want us to embark on the law and look at Article 99 of the Constitution, because what we find right now is it's not a new issue that is arising. You do recall in 2013, Ndong Wainaina of International Center for Policy did file a petition in court challenging the suitability of His Excellency the President and the Deputy President. Yeah. And I can tell you the petition, it was heard by a 5-judge bench. And the issue was, you boil down back to Constitution, and it is Article 99 that provides for qualification or conditions with which a candidate can be barred, yes, from vying. And I'll tell you, there was an observation about Article 99. Let me give you, we have the Constitution here. We have Article 99 2G, which says that a person is disqualified from being elected as a member of parliament if the person is subject to a sentence of imprisonment of at least 6 months as at the date of registration as a candidate or at the date of the election. And then you go to the same Article 99(3), which provides that a person is not disqualified under a Clause 2 unless all possibility of appeal or review of the relevant sentence or decision has been exhausted. Okay. Now, that is the crux of this matter.
That is where the problem starts.
That is where the problem starts. And when this problem starts, before I proceed, is one, the Constitution envisaged that would have a situation where their candidates would have allegations against them. Yeah. Yes, and investigations are ongoing. But you boil down to the same Constitution in Article 50, sub-Article 2, which presumes there is a presumption of innocence against all accused persons for any allegations. The reason why I wanted us to play that clip is you will note there's no conviction against Mutua. Yes. They are just allegations. There's no conviction against Anne Waiguru. They are just investigations. He's actually a prosecution witness. There's no conviction against Asman Kamama. And so when these matters came up, in 2013, there was the same civil society was the opinion that we need an objective test. Mm-hmm. The objective test is that you want to look at, we call it, you look at an ordinary person. How would they view you? In the face of these allegations that you'd have, are you fit to hold office? Okay. But the Constitution, and what I'm saying, is the law is very clear. Unless now these two standards are met, there will be no basis whatsoever for IEBC to intervene. Yes? Oh. There would be no basis whatsoever for the IEBC to intervene and stop the candidature of any person. And I'm telling you, the matter will find itself back to court.
Kipto, this is heading nowhere.
If I can quickly beg to differ with my senior colleague. Yes. In that, when we interpret the Constitution, we don't interpret one chapter in isolation of the others. Secondly, he's mentioned a very good concept, the Grundnorm. The Grundnorm will be the initial constitution, which is where, in fact, in jurisprudence, we'll call it the first constitution. In this case, if we were to refer in our case, I wouldn't refer with the text we have in the in the form of the written constitution, but I would say the idea that people or the citizens came up and talk about that we, the people, have decided to be bound. Now, that speaks to the spirit of the Constitution. There's a key reason why in the previous Constitution we never had Chapter 6. We never had anything to do with leadership and integrity. We only had what he's mentioned, which is quite clear. Okay. There isn't any argument about qualifications. Who qualifies, who can be disqualified. So he's very okay with that. But my problem would be, if that is the basis, then we wouldn't have any reason to bring Chapter 6. The Chapter 6 seeks to answer a particular question, that is integrity. And when it comes to integrity, there are set standards set. That is why the same Constitution only gave guidelines and said we anticipate the legislature to come up with a particular legislation that brings into effect. And that's why the first thing I said, the mess started with Parliament being unable to come up with a strong legislation.
Yeah.
We have a legislation. In fact, even parliamentarians themselves have been on record to say we failed in that. If you remember the Commission on Implementation under Nyachai, I remember they protested vehemently during that time and said, we are just rendering it waste, the Chapter 6. So when it comes to the issue of Chapter 6, when you talk about integrity, so does it mean it flies in our face, for example, if a parliamentary report can come out and say this person is unfit to hold office, and that is basically after a due process, after a critical investigation, inquiry? So does it mean we rubbish all that? So why would we then set up this standard and say we expect you to have met this particular standards? So he is correct to the extent that unless convicted, that automatically bars you, and that's a practice world over. But there is the aspect of moral considerations. There is the spirit of the Constitution, and the spirit was basically on the issue of ethics. Ethics is not what can lead to your conviction. Let us separate that. Secondly, my only concern, if I told you, my only problem with the timing is that what time are we doing this?
But
we are even inconveniencing the same parties. Why did we let them run, spend their money, spend their energy to the extent that their parties have cleared them? That's why my feeling would be, if they go to court right now, they have a strong argument as to their political rights, and not just themselves. A voter can go sue and say, my political rights, my political choices that I'm to make are to be infringed by this decision because it has come too late on. So on the timing and the procedure, that will be the only problem.
Then probably someone else would argue, then it should have been the role of the political parties to actually sieve them out.
Very true, and that is what we were to expect from the political parties. But do we have really the political parties you're talking about? Parties that cannot even do nominations? Show me one party that had flawless nomination. If they couldn't do a simple thing like nomination. Now, don't you think you are expecting too much from a party to do? Surely. In fact, the funny bit about our political parties, they are personality based. In terms of it is always more or less a collection of individuals. And if we were to sit down and pass the integrity test, trust me, it is a possibility no party would be in existence. So that is, in fact, it is a pile-up of more or less, I say, inertia and inability of the institutions and the party. Then look at this. IBC will be faced with this question. If you have a query about an individual, and that is where my concern comes in. If you bring a query, for example, against Anne Waiguru, the first thing IBC will ask, as Commander had aptly said it, what is the basis? Show me something that I can use to justify my decision to bar. So that takes you back to who? The institution. Who is the institution? EACC. Has EACC cleared this person? You are back to square one. Are you seeing that? Because IBC will bar this person, and when this person goes to court, our courts are courts of records. So the court will ask, just justify your decision.
Why.
And IBC will say, we based it on recommendation from 1 to 3. Where is it? Then the court can interrogate the same. Who are supposed to give this information? For example, let me pick out Asman Kamama. Asman Kamama is being accused of...
let me hold on.
Specifically, I think if I can pick out the specific one,
Asman Kamama,
it is to do with violence
ongoing clashes.
Ongoing clashes. Yeah. You see, who undertakes such investigation? The Directorate of Criminal Investigation is supposed to come up with a report. You will not be surprised that Asman Kamama has a clearance from DCI, Certificate of Good Conduct. So you can imagine if Asman Kamama shows up in court with a Certificate of Good Conduct just to confirm that I'm being accused of this, and the line agency that is supposed to pass this test has issued me the Certificate of Good Conduct. What does IBC do? It ends up with an egg on its face. That's why I'm saying we need, this election is a process. Integrity is a process. It's not a one-off thing. So the civil society are very correct, are very true. They are doing the right thing, but they're just pinpointing where our problem starts from. The timing is now. Do you think you'll get it right within 2 months? We are 2 months before the election. You know how our voting happens. You know how our politics work. You think you can stop someone like Hassan Joho and go tell Custodian that we've stopped him on
this guy because of his papers, because of qualifications and all that.
But I support the steps whatever the civil society is taking, because the idea of Chapter 6 was to bring order. Let it be that a person cannot misappropriate and mess up knowing that nothing can happen. You know, you can't fight impunity if you don't start somewhere by showing, even though our institutions will fail, let it be on record that we protested, we brought it out, so that if anything happens, that can be a basis and say, remember that time we said this person is unfit. You see what now is happening? So that should be the basis. So we shouldn't just throw away the baby and the bathwater, but rather we should focus on where did we get it wrong. Right from the process after election, because I think we always have a way of doing our election and electoral process only during the election here. We forget that it is a build-up.
It is a build-up. Okay, listen. So the list is out.
Yes.
Commander, is this heading anywhere? Or
Let me tell you, what the civil society is engaging in is a game of musical chairs as they did in 2013.
Okay, listen, I need to just cross over to Director of Public Prosecutions, Keriako Tobiko. I believe he's appearing at the Senate over that case touching on Kakamega Governor Wycliffe Oparanya, who was supposed to appear before the Senate Public Accounts and Investments Committee. He did not. Let's listen in a little bit. Then we'll continue this discussion.
Chair, all I wish to say. Thank you.
As a follow-up,
Yes.
a DPP, every time I listen to you in Parliament, I have no regrets that you became our DPP. What is disturbing me now is that this committee, there's no doubt, we are going to say one, Governor Wycliffe and that of Paranya is not fit to hold public office. We will not be the first to say this in the last few weeks, because even in the National Assembly, the Public Accounts Committee has also said that Anne Waiguru is not fit to hold public office. Now, having said it is not enough. What, on your advice, should we do, if anything, to ensure that what we say moves from being what we have said to being something which is enforceable? Do you mind? Do you think simply by us saying he is not fit to hold public office is enough for that to provoke IEBC not to accept his nomination papers? Or is it your advice to us that we should do more? Or rather, more should be done? Would it require that a court is moved so that that court can then make an order to the IEBC? And if so, who then should move the court? Should it be the Senate, or should it be, in my thinking, the DPP? The DPP to move the court that in your expanded jurisdiction of understanding what goes on in public offices, you have found that a man has been declared unfit to hold public office, and therefore you're moving the court that it orders IEBC to comply with that particular finding by the Senate, and of course by extension, in Anne Waiguru's case, by the National Assembly.
Okay, DPP. Thank you, Chair. And, I do not want to assume the role of the Attorney General, neither do I want to suppose to advise IEBC, because it is not within my competency or mandate. But just looking at Article 193, 2G, a person is disqualified from being elected as a blah, blah, blah. If the person has been found in accordance with any law to have misused or abused of, or has contravened, I do not read anywhere there saying has been found by a court of law. Again, my personal opinion, that the authority, but the authority is about an important issue. Do you have to get a declaration by the court? I do not. That is a matter that I think should be addressed. That is a question that should be addressed to the Attorney General and to the institutions that have the mandate to clear candidates. To start.
Thank you so much. Yeah, yes, Bonnie.
Mr. Chairman, because this is a matter that we are transacting through the public, it's good for us to take advantage of the presence of IEBC here and the DPP, so that I make the following statement. From what I hear you saying is that what we have found, or what the National Assembly has found in respect of Anne Waiguru, we should go further as the Senate and as the National Assembly and write to the IEBC telling them that pursuant to Article 193, 2G, we have found that Wycliffe Ambetsa Oparanya is not fit to hold public office, and therefore his nomination papers should not be accepted. And similarly, with the National Assembly, Public Accounts Committee, in respect of Anne Waiguru. Then if they refuse, we would then need the interpretation from the court to either agree or disagree with us and you that in G, it doesn't say it should be the court. It doesn't.
Let me just add something. Thank you very much. Thank you very much, DPP, and thank you, Bonnie. Let me put it the following. The reason why we called these institutions is because what I said earlier, that we must all work together in ensuring that the Constitution, which people are still learning, by the way, is obeyed and implemented, particularly with regard to devolution, which Senator Karwe said perhaps was the biggest present to Kenyans from the Constitution. Having said that, this committee has gone an extra mile to validate its responsibility with other state institutions, so that together we can appreciate the importance of one another or each other in trying to ensure the use of public funds by all government institutions, in our case, by devolved government. Now, the DPP has really helped us and told us in the final analysis, what I've been looking for is actually crystallized in Article 193, 2G. That's a fulcrum of the debate. But we need...
Those are live proceedings. The Senate Public Accounts and Investment Committee looking into the conduct of Kakamega Governor Wycliffe Oparanya. He has refused to appear before that committee. And in attendance, we have the Director of Public Prosecutions, Keriako Tobiko. There is the representation as well from the IEBC. The senators, they're trying to figure out what exactly they're supposed to do with Wycliffe Oparanya. In studio, you have Joshua Kipto and Murigi Kamande, both advocates of the High Court. Gentlemen, what can the Senate do with Oparanya?
One, when appearing before those committees, it is said that they have the powers of the High Court when it comes to contempt, the matters of, or the issue of contempt. So they can declare that Oparanya is in contempt of the committee.
And seek a warrant.
Yes, and seek warrants for his arrest. Yes, that would be one of the avenue. The other one would be to make a finding, an adverse finding against him, because he was granted an opportunity to present his side of the story.
How far is that going to go?
You see, at the end of the day, what you find is you have reports, one chant being one after the other, or coming one after the other, with recommendations by these committees in Parliament, or even Senate. But the question you ask yourself, how effective are these reports? And that's the question that was being raised. How do you move these recommendations from just mere recommendations?
Bonnie Khalwale has actually
yes,
raised
that question by Bonnie.
Yeah.
How do you move them from being just recommendations to action? And that has always been the disconnect. You'll always find that so many reports have come up and all of them are just stored. So you have recommendations, all of them are stored, nobody takes up that action. So now when it comes to Oparanya, the worst that they can do is to declare that he's in contempt and seek for his warrant of arrest, or in the alternative, go ahead and make their recommendations, his contribution notwithstanding.
Kipto?
Akip, I think it's simply because, and that is where we always get it wrong.
What?
We have institutions in Kenya who fear exercising their mandate. Let me give a solution. You've asked a simple question. What happens next?
Yes.
If the PSC, for example, has two things, it can give a declaratory statement that we adjudge this person unfit to hold office. That's enough for any petitioner, any voter to petition in court, and you petition against IBC, whereby you're seeking the court to uphold the ruling or the finding of the committee, which in this case bars IBC from accepting credential of this person. That is the easiest way out. And I think for the last 4 years, there has been a key steep rise in whatever this kind of public interest litigation coming up. That's number one. And that is the easiest way, that you don't even spend anything. If the civil society can pick up
the
that...
cheapest way.
Oh, it is the cheapest. and I would feel the civil society should go beyond just issuing statements. Take it up. Like for Anwar Guru, there is a PSC report. Pick it up, go to a court of law and say, in accordance to this particular article, we want the court to uphold, and in that case, give orders against IBC. That is one. There is number two. Anytime someone is found culpable, that is the word we are looking for.
Culpable.
Beyond just being declared unfit, if you are found culpable, then what are we waiting for? DPP is there. EACC, in fact, EACC was part of the inquiry. Remember, the parliamentary committees are inquisitorial. They don't charge you. They only do recommendation. And if part of their specific recommendations is that you be charged with economic crimes, why did we have DPP? Why did we have the economics? Why did we have the EACC? It was because there are avenues the same can be brought in a court of law. The difference here is, as Commander says, it is a game of musical chairs because of one reason.
Right.
Inertia and the fear, not even fear, deliberate inaction by the same institution. If the file is taken to the... In fact, if I were there and I would... if Bonnie Halwale would ask me this question, I would ask Bonnie Halwale, why don't you guys finish your report, write and recommend that this person is supposed to be charged, forward the file. Then let it be that the DPP has refused to charge.
Or it failed at the DPP's door.
That is the point. So our institutions, like you have some sense of institutional disconnect.
Okay.
There is no seamless working. Let me give, maybe if we can borrow from elsewhere. Have you seen how the Americans work? If the Senate comes into, like, let me pick out the Donald Trump investigation as to the Russia meddling.
Yeah.
Look at how those institutions are working seamlessly. FBI is in, there is a special prosecutor, there is whatever, there is the House of Congress also investigating, that at the end of the day, they will give our recommendations, FBI will be waiting, the Department of Justice will be waiting. In fact, if you look at how the American works, the DOJ is just waiting. That is why they said a special prosecutor has to be appointed, because they can only act based on a report. In Kenya, we don't have that seamless connection between the entities.
Okay.
Yeah.
So if I hear you correctly, you're saying
Yes,
for individuals or aspirants whose recommendations have been given probably in Parliament, someone can actually just...
You can proceed to court and seek orders against IBC
orders
from receiving their certificate.
So that is specifically to individuals who have reports.
There must be a basis. You know, you can't go to court without a basis. The court will ask you, one, what is your interest in the matter? Let me assume you are a voter in that particular area, or alternatively, you are a Kenyan citizen voter.
Very good. There
So
must
that's where
be
you
a
start
basis.
from. Yes.
There must be a basis.
Yes.
What about the guys who've been mentioned today by civil society?
Same thing. You know, you
So
can't,
clearly...
you have to... No. It is not a defeatist thing.
Yeah.
Remember this. The civil society have a basis. See, they have raised allegations.
Those are allegations.
No
He
problem.
actually put them
but
allegations.
the allegations are based on facts. Why don't you use the same? And that's where we say, you know, now that our institutions have failed, proceed to court directly. What prevents the civil society going to court and applying for orders against IBC, receiving the same credentials on the basis of this? Because once it goes to court, our courts of record, they will ask, substantiate.
Okay.
What is difficult in that? If indeed they have facts, what is difficult in substantiating?
Okay.
Now, let me weigh in on what he's saying. And I'm saying this. We have to go back. If we want to realize how the effectiveness or non-effectiveness of Chapter 6, we go back to 2013. and have mentioned petition number 552 of is it 2013? Yes, of 2012 or 2013. That was the International Center for Public Policy against His Honorable Uhuru Kenyatta, His Excellency Uhuru Kenyatta, and the Deputy President. And the basis was this, that the two had already been indicted at the ICC, and their cases were ongoing. And therefore, it was fine. Those were not just mere allegations. This was an indictment. This is a matter that is already ongoing in court. The charges have already been confirmed, and the hearings had already been set. But the court was so categorical, and he said when it comes to these matters, it is not just an objective test whether a person is facing charges or not. If a person is facing these charges, we have to go back and presume them innocent
until proven guilty.
Okay. Yes. And then at the same time, that's what I'm saying. You look at, and that's the reason why you see, and I said it was a game of musical chairs, that these civil society organizations know that if you go, they want to judge you in the court of public opinion. That is the reason why they have to read out all those allegations in the media to get them in the media. But they will not go to court.
I need to wrap up, guys.
Quickly.
I need to wrap up.
There is something that maybe I can add on. There's a case already pending at the Supreme Court, if I'm not wrong, by the Kenya National Human Rights Commission.
Yes.
Have a keep an eye on that, because they have sought advisory opinion from the Supreme Court as to how Chapter 6 can be implemented.
Okay. People, thank you so much for sharing your sentiment. Joshua Kipto, Murigi, Commander